Wraith of Injustice by Sarah J. Nilsson. This is the true story surrounding the death of Heidi Sue Dowland, born November 18, 1980, and tragically killed in a plane crash on January 13, 2019. Wraith of Injustice portrays the haunting and destructive consequences of injustice in the aftermath of the death of Heidi Sue Dowland. A wraith is a ghost that persists. Episode 8, USA v. Anderson. On November 14 of 2023, in the U.S. District Court for the District of Arizona, a grand jury charged Christopher Adam Anderson on 3 counts. Count 1. On or about January 13, 2019, near Kingman, Arizona, Christopher Adam Anderson flew an aircraft with a passenger without proper certification, where that flight crashed, resulting in Heidi's death. And Anderson did wantonly and recklessly disregard human life, and his actions were the proximate cause of Heidi's death. Count 2. On or about December 15, 2018, in the District of Arizona, Christopher Adam Anderson piloted an aircraft with a passenger, knowing that his airman certificate did not allow a student pilot to act as pilot in command of an aircraft carrying a passenger. Count 3. On or about January 13 of 2019, Christopher Adam Anderson served as a pilot of an aircraft with a passenger, knowing that his airman certificate did not allow a student pilot to act as pilot in command of an aircraft that is carrying a passenger. Representing the United States in this case, from the U.S. Attorney's Office in Phoenix, is Abby Broughton Marsh. This indictment was originally sealed until the arrest of Christopher Adam Anderson. Assisting Abby Broughton Marsh is Gary Restaino, another U.S. attorney. Let's look at the Federal Code 18 U.S. Code 1112. Manslaughter is the unlawful killing of a human being without malice. There are 2 kinds. The kind in question is involuntary. It is involuntary if in the commission of an unlawful act not amounting to a felony, or in the commission in an unlawful manner, or without due caution and circumspection of a lawful act which might produce death. Let's look at 49 U.S. Code 46306 Bravo 7. This is for the 2 flights, the one on December 15, 2018, and the one on January 13, 2019, when Anderson knowingly and willfully served as pilot in command, carrying passengers when he was not supposed to. What follows next is the Department of Justice conflict memo, showing there was no probable conflict with any of the 3 judges on this case. There was no probable conflict with Magistrate Judge Camille Bibles. There was no probable conflict with Judge Dominic Lanza. And lastly, there was no probable conflict with Magistrate Judge Michael T. Morrissey. On November 15 of 2023, 4 years and 10 months after Heidi was killed in the plane crash, with Anderson, a student pilot, at the controls, Anderson's arrest warrant was finally filed in the U.S. District Court for the District of Arizona. These documents would remain sealed until his arrest. Barely 2 months later, on January 7, 2024, Anderson, now aged 47, was traveling on southbound I-15 near exit 10 in Washington City, Utah, making his way back toward Arizona, when he was pulled over by Utah State Highway Patrol and arrested. He had been stopped initially near the Browse exit, but was released after he passed a background check run by emergency dispatch. It wasn't until several minutes later that the warrant emerged on the National Crime Database, which is when the trooper requested assistance to stop Anderson again.
A traffic stop on Interstate 15 in Washington City over the weekend led to the arrest of a man wanted on a federal warrant issued out of Arizona. On Sunday, the pilot, 47-year-old Christopher Adam Anderson, was arrested in Washington County shortly after 2 p.m. Anderson is facing federal charges, including 1 count of involuntary manslaughter and 1 count of registration violations involving an aircraft. The case was filed following a plane crash reported on January 13, 2019, involving a Piper aircraft that crashed near Kingman, Arizona. The aircraft was carrying 2 occupants, including Anderson, the pilot, and a 38-year-old passenger and owner of the plane who was killed in the crash. And Anderson is scheduled to make an initial appearance in U.S. District Court in St. George later this week. Until then, he remains on a federal hold in Washington County. This is Cody Blowers reporting for St. George News, your #1 source for local news.
Following the arrest of Christopher Adam Anderson, the case is assigned to Magistrate Judge Paul Kohler in the U.S. District Court of Utah. On January 8, 2024, Magistrate Judge Paul Kohler ordered a hearing, an initial appearance Rule 5 hearing for January 11 at 10 a.m. Rule 5, under the Federal Rules of Criminal Procedure, states that a person making an arrest within the United States must take the defendant without unnecessary delay before a magistrate judge. Maya Devine, Heidi's daughter, saw the news and posted on social media on January 10, 2024. So on January 11, 2024, Christopher Adam Anderson appears in front of Judge Paul Kohler. The court appoints a federal public defender, Rob Hunt, as his counsel, and then the defendant is advised of his rights. The defendant also waives his identity hearing, and he acknowledges his identity on record. The government sought detention in this matter, and the court heard the argument regarding this issue of detention. For the reasons stated on the record, the court ordered the defendant detained in the U.S. Marshal Service custody for transportation to the charging district, which was Arizona. Representing the United States in the U.S. District Court in the District of Utah was attorney Angela Reddish-Day. As I previously mentioned, the court appointed federal public defender Rob Hunt to this case to represent Christopher Adam Anderson, and the representation was to continue for any post-sentencing activities initiated by the U.S. Probation Office. And so we see that Christopher Adam Anderson was to be temporarily detained. Also on January 11 was entered a waiver of Rule 5C3 hearing. 5C3 in the Rules of Federal Criminal Procedure explain procedures in a district other than where the offense was allegedly committed. Then the commitment to another district was signed by the Magistrate Judge Paul Kohler to transfer Christopher Adam Anderson from the District of Utah to the District of Arizona. Next on the docket, we see a notice of transmittal that the case had been transferred to the District of Arizona per the order of the judge on January 11, 2024. And then all minute entries were sent to Arizona. This is the waiver of Rule 5 and 5.1 hearings by the defendant. And then we have some minute entries also showing that the U.S. Marshal Service was to take the defendant into custody for transportation to the District of Arizona. And then we have the criminal docket, which was terminated in the District of Utah on the 11th of January. And as you can see, this all started after his arrest on the 7th, so the docket shows entries from the 8th of January. I saw the Daily Courier, Prescott's local newspaper, on January 16 of 2024, when I stopped in Skull Valley for coffee while on a motorcycle ride with my other half, Bill. I thought it would make a great case study for my students. You see, I'm a long-time pilot, a lawyer licensed in Arizona, and a law professor at Embry-Riddle Aeronautical University, teaching AVLAW, drone law, and advanced air mobility. I began researching the case, befriended Heidi's family, and proceeded to make these videos. This is the document unsealing the matter, which had been sealed since November 14 of 23, but the court, sua sponte, which means on their own accord, had unsealed this case on the 4th day of March 2024, and this was signed by the Honorable Deborah M. Fine. Also on the 4th of March, we see a notice of appearance by attorney C. Kenneth Ray II. It would appear that Christopher Adam Anderson has retained him as counsel. So this is the attorney advising the court that he is now representing the defendant in all further proceedings in this matter. C. Kenneth Ray II is a criminal defense attorney out of Prescott, Arizona. March 4, 2024, in front of Magistrate Judge Deborah M. Fine. This was the time set for initial appearance and arraignment. However, defendant just retained counsel and requests additional time to allow pretrial services to interview the defendant. The court finds it appropriate to reset the arraignment and detention hearing to allow pretrial services to interview the defendant and provide a report to the court and counsel, as well as to allow defense counsel to be present in person for these proceedings. Defendant shall remain temporarily detained. As required by Rule 5F, the United States is ordered to produce all information required by Brady v. Maryland and its progeny. Not doing so in a timely manner may result in sanctions, including exclusion of evidence, adverse jury instructions, dismissal of charges, and contempt proceedings. So what is this Brady v. Maryland case? It was a case where the U.S. Supreme Court addressed the issue of prosecutors suppressing evidence favorable to the accused. The Brady decision ruled that the defense has the right to examine all evidence that may be of an exculpatory nature. The prosecution will not only release evidence that the defendant might be guilty of a crime, but also release all evidence that might show that the defendant is innocent as well. Rule 5F requires judges to inform the prosecutors of their obligation to produce exculpatory info, and provides that courts may hold prosecutors accountable if they do not comply with a Brady order. Appearing for the United States was Assistant U.S. Attorney Todd Allison, and for Christopher Adam Anderson was C. Kenneth Ray II. The defendant was present and in custody, and the arraignment and detention hearing was set for March 6th at 9:30 a.m. in courtroom 303 in Phoenix. And as I mentioned, Magistrate Judge Deborah M. Fine reminded the prosecutors of Rule 5F. March 6, 2024, the arraignment and detention hearing occurred for Christopher Adam Anderson. The defendant entered a plea of not guilty to all pending counts, and the detention hearing was held whereby the parties proceeded by way of proffer and arguments. And then defendant's Exhibit 1 was admitted into evidence. The defendant was ordered to be released on his own recognizance with conditions. and the conditions of release are then reviewed with the defendant on the record. Appearing for the United States was Assistant U.S. Attorney Glenn McCormick, and for the defendant, Attorney C. Kenneth Ray II. The defendant was present and in custody. Pre-trial motions were to be due within 21 days, and a jury trial was set for May 7 at 9 a.m. in courtroom 505. The exhibit list by the defendant includes Exhibit 1, letters. I'm going to review now the order setting the conditions of release. It is ordered that defendant is subject to the following conditions and shall appear at all proceedings as required and to surrender for service of any sentence imposed. Shall not commit any federal, state, or local crime. Shall cooperate in the collection of a DNA sample if the collection is authorized by 42 U.S. Code 14135A. Shall report as directed to the U.S. pretrial services. Shall reside at the address on file with pretrial services and immediately advise his attorney and pretrial services in writing for approval prior to any change in residence address, mailing address, and telephone number. Shall not travel outside of the state of Nevada unless prior court or pretrial services permission is granted to travel elsewhere, except that with at least 2 days prior notice to pretrial services, the defendant may travel directly to the prosecuting district and through all states and counties between the defendant's authorized state of residence and the prosecuting district for court purposes and lawyer conferences. The defendant shall not travel out of the United States unless prior court approval is granted to do so. Shall avoid all direct and indirect contact with any persons who are considered alleged victims, including family, potential witnesses, co-defendants. Contact exclusively through counsel is allowed. Shall maintain weekly contact with his attorney by Friday noon of each week. Shall surrender all travel documents to pretrial services by March 11, 2024. Shall not obtain a passport or other travel documents during the pendency of these proceedings. Shall maintain or actively seek employment, combination of work, school, if physically and medically able to do so, and provide proof of such to pretrial services. Shall not operate an aircraft. Shall not possess or attempt to acquire any firearm, destructive device, or other dangerous weapon or ammunition. Shall consume no alcohol. The defendant shall participate in alcohol treatments, submit to alcohol testing, and make co-payment toward the cost of such services as directed by pretrial services. The defendant shall not obstruct or attempt to obstruct or tamper in any fashion with the efficiency and accuracy of any substance use testing or monitoring. Shall not possess or use a narcotic drug or other controlled substance unless prescribed for the defendant by a licensed medical practitioner. And lastly, shall surrender Mojave County credentials to pretrial services by March 11 or within 3 days of receipt of such. What follows in these documents is the advice of penalties and sanctions should Christopher not comply with the above. And the Honorable Deborah M. Fine signed the order releasing the defendant on March 6th of 2024. What we have here is the minute order re-exhibits as to Christopher Adam Anderson. It is hereby ordered that the exhibits marked whether or not received as evidence in the above entitled case at the time of the detention hearing, which concluded on March 6, 2024, are returned to respective counsel. Counsel are directed to retain custody of the exhibits until the case has been completely terminated, including all appeals pursuant to a local rule of Civil Procedure 79.1. Stay tuned for episode 9, Death by 1,000 Continuances, as we watch the court drag its feet, further delaying the justice that Heidi's family have been waiting for over 6 years now.